welcome back to this final segment of this law session in English legal system, dealing with, of course, sources of law. We have looked at some of the main sources. What I want you to bear in mind, though, that this is not all of them. Remember that the idea of law sessions, of course, is to assist you in understanding the primary principles in this area. So, of course, there are other areas that you can certainly look at. As I say, looking at the laws from other jurisdictions may also be a source. So we have started off in the first segment by looking at EU law. We've looked at statute, we've looked at case law, we've looked at delegated legislation. This final source, of course, is custom. Now this, as you no doubt happily know, is that this won't be a terribly long final segment, because we're looking at custom, which is a little bit of a carryover from case law. Because when you look at case law and the idea that case law is a source, you're looking at something that has been practiced and has come forward for hundreds of years. Well, custom follow that same kind of line. Well, custom can be a source of law, but not just in a vacuum. It can be a source of law, but it must fulfill certain criteria. Now, when you look at the whole basis of the common law, arguably it was custom. What you had when you look at the historical aspect of it was you had the itinerant justices, going around. Even now, within some jurisdictions, you see them have a circuit court. Certainly when you look at some Commonwealth countries, you have judges who go from the main court and go out into the countryside and so on. And they have, as I say, circuit court. And this happens at particular times of the year. Well, this is all bound up in the whole custom scenario. You had the itinerant justices who were sent out by William the Conqueror, who examined different local practices of dealing with disputes and crime, and it filtered out the less practical and unreasonable ones, and ended up with a set of laws that were to be applied uniformly throughout Britain. This does not, of course, mean that custom was ever law. The law was created by the decisions of judges in recognizing some customs and not others. Sometimes when you even look at some of the cases, for example, when you look at statutory interpretation, you will see that it is precisely because of custom that some things make sense. So the idea here, as I say, is that custom acted as a source, but you still must go back to the case law and the decisions there. So when can custom be a source of law? Well, to be regarded as conferring legally enforceable rights, a custom, as I said, must fulfill certain criteria. The first is that it existed from time immemorial. Now, this was fixed by statute in 1275 as meaning since at least 1189. Now, this is interesting because when you come to do land law later on, you will see that when you're looking at an easement, you will see this phrase of time immemorial being something which has taken place since 1189. But that was because in the statute of 1275, it says the term time immemorial means going back to 1189. In practice today, claimants will usually seek to prove the custom has existed as far back as living memory can go. Now, when you look at the 1275 statute, it said time immemorial was 1189. But when you look at the way contemporary society looks at it looks at it from living memory, meaning who can remember, whose grandfather, great-great-grandfather can remember when everybody walked across that piece of land, for example. So what's happened is when you look at contemporary society, the custom has existed as far as they're concerned, as far back as living memory can go, often by calling the oldest local inhabitant as a witness to say, can you remember anything different than what is here? And if he says no, so you're getting Mr. Brown, who is 105 years old, and he said, well, from I was a child and my father used to tell me that everybody used to use this, then that is generally taken as time immemorial, notwithstanding this 1189 point. Well, in the case of Simpson and Wells, which is an 1872 case, there was a charge of obstructing the public footway by setting up a refreshment stall, and this was challenged by a claim that there was a customary right to do so derived from statute sessions, which was ancient fairs which were held for the purpose of hiring servants. Now, it was then proved that statute sessions were first authorized by the Statute of Laborers in the 14th century. So the right could not have existed since 1189. The fact that there is a starting point which can be found will mean that time immemorial will not, as a custom, be considered based on the facts. You would need to go back and look at the statute. So by custom, first thing we look at time immemorial. Next thing, of course, from custom, reasonableness. Now, a legally enforceable custom cannot conflict with fundamental principles of right and wrong. So a customary right to commit a crime, for example, could never be accepted. So just because it is a custom in a particular area for it to be prevalent with incest, for example, will not necessarily mean that because it's a custom, it's going to be the law. Certainty and clarity are also requirements when you look at custom. It must be certain and the custom must be clear. So the locality in which the custom operates must be defined along with the people to whom rights are granted. So for example, local fishermen or tenants of a particular estate, and what needs to be known as well is the extent of those rights. So when you look at the case of Housen and Wells in 1806, the tenant of a manor claimed a customary right to take as much turf as they needed from their lawns from the manorial commons. Now this was held to be too vague, since there appeared to be no limit to the amount of turf which could be taken, which makes sense. He could dig up the whole of the manorial lawn and take it over to his own place. So it must have certainty and clarity. The locality is also important in determining whether or not a custom is a source of law. The locality must be specific to a particular geographic area. Now, where a custom is recognized as granting a right, it grants that right only to the persons specified. So a custom giving fishermen in Lowestoft the right to dry their nets on someone else's land would not give the same right to fishermen in Grimsby, for example. Custom is only ever a source of local law. The other thing as well is continuity. It must have existed continuously. The rights granted by custom do not have to have been exerted or exercised continuously since 1189, but it must have been possible to exercise them at all times since then. Now, in the case of Wild and Silver 1963 case, a landowner wishing to build on land where the local inhabitants claimed a customary right to hold an annual fair argued that the right had not been exercised within living memory. The court nevertheless granted an injunction preventing the building. Now, you must also look at it being exercised as of right. It must have been exercised peaceably, openly, and as of right. This is one of the things when you look at, for example, like with adverse possession. So customs cannot create legal rights if they are exercised only by permission of someone else. So in Mills and Colchester Corporation in 1867, it was held that a customary right to fish had no legal force where the right had always depended on the granting of a license, even though such license had traditionally been granted to local people on request. Now, consistency must be consistent with other local customs, as I say, and it must be, for example, if a custom is alleged to give inhabitants of one farm the right to fish in a lake, it cannot also give the inhabitants of another the right to drain the lake. It must be consistent. Now, the usual course where a conflict arises is to deny that the opposing custom has any force, though this is not possible if it has already been recognized by a court. The custom must be obligatory as well. So where a custom is imposing a specific duty, that duty must be obligatory. So a custom cannot provide that the lords of a manor grant villagers a right of way over his land only if he likes them or happens not to mind people on his land that day. It must make an obligation on him. It must conform with statute. So a custom which is in conflict with a statute will not be held to give rise to law. That then, of course, brings us to the end of custom as a source, and we see the requirements that it must meet in order to, of course, have that kind of basis to give rise as a source. Again, I will ask you to join me for the law session on precedent and statutory interpretation, which certainly have a bearing in respect of this law session.